doing so, but I asked Mr. Scalia to sit down and shut up.
Your Honor, really, Mr. Willick, this is really completely unprofessional. This is...
Stop!
The secret Marshal Willick tapes is a glimpse into the corrupt world of family law, with never-before-seen court footage that was meant to have been destroyed years ago due to the controversial nature of what this footage contained, and how it portrayed the godfather of family law, Marshal Willick.
I found out my ex-husband had hired attorney Abrams. I borrowed $5,000 on my car, and I paid attorney Willick $5,000 to represent me, to find out he and Abrams were lovers. And after taking my money and telling her everything I told him and telling her how to fight it, he said he couldn't help me. They were good friends with Abrams Law Firm. I lost everything I owned. I had a $30 million a year business. My ex-husband got all of it because something's going on in that courtroom between certain attorneys and certain judges.
Eric, could you explain what happened in the video here where Judge Ritchie seems to be critical of the conflict of interest or bias between Marshal Willick and the prior judge before this came to Judge Ritchie's courtroom?
Let me ask you this, okay? Because this record stinks. When did you start representing a relative of the judge? You filed your notice of appearance on February 6, 2014?
I'm sorry, I don't have that date.
I'm just saying, I mean, is this order even viable?
From my understanding, Judge Ochoa actually hired Marshal Willick to do some work for him directly, and neither one of them said anything to us or our counsel at the time. This thing took place for well over 2.5 months, at which time he was also billing my ex for work and doing multiple briefs against me for failing to comply to an order that Judge Ochoa had made.
So they're operating for a period of time with a conflict of interest right there. And eventually what happens is that Judge Ochoa recuses himself.
Exactly. Yeah, Marshal Willick never once said anything about the fact that he had been hired by Ochoa to do any work. Ever.
So when Judge Ritchie over here makes these comments, I mean, he makes pretty harsh comments saying that this case stings, and I think he talks about an order and questions whether it's even binding under those circumstances. That's what Judge Ritchie is referring to?
Yes. Let me ask you this, okay? Because this record stinks. When did you start representing a relative of the judge?
I'm sorry, I don't have that date.
I'm just saying, I mean, is this order even viable?
So one of Willick's attorneys in his office is a sexual predator.
Yes.
Tell me a little bit about that.
Oh, Richard Crane. As far as I know, they've been partners for the longest time. Richard Crane is a Tier 2 registered sex offender. It's on the registry.
And he's a family law lawyer.
Yeah.
What did he do? What was his crime?
I believe it was Henderson PD that did a sting back in 2014, around there, I want to say. And it was an online thing where they're trying to catch sexual predators online talking to kids. Mm-hmm. And I guess Richard Crane believed he was talking to an underage minor. It was actually Henderson PD that he was talking to, and he got arrested. He got busted. Mm-hmm. Trying to pick up on an underage minor, trying to have sex with him. He got arrested, he got charged, and he lost his law license for a couple of years. However, even though he lost his law license, Willick was still allowing him to work in the Willick Law Group and still billing everything Richard Crane did. I mean, if you got pictures of kids, investigations, naked pictures or whatever, this guy's seeing all that. He's a registered sex offender.
My research shows that despite being removed from the profession, Rick Crane was still appearing in bills sent by Marshal Willick to his clients.
I heard that Marshal Willick helped get Richard Crane reinstated as an actual licensed attorney here in Nevada.
Oh, wow.
Which by law I didn't think was allowed.
I mean, how is that even possible that Marshal Willick has this much power within the courts to be able to do these sort of things that normally would be impossible and or unlawful?
I had to take a lot of money. You know, they say money talks, bullshit walks.
It's the most unqualified, the most dangerous people are actually running the shit show. Mm-hmm. And what I mean by that is, like, look at Willick, who's sitting there in Reno, literally masturbating in front of 14-year-old girls that are changing in the dressing room.
Yep.
This is all covered up. This is the head. It's Willick.
Yep.
Marshal Willick.
And to clarify, I didn't hear Reno. I heard actually happened in Carson
City. I'm sorry. Carson City.
That's what I heard. That's what people are saying. It's all over the legal circle in Vegas, but nobody does anything about it.
This gentleman right here, all the way to the left, is Toby Mathis. He's the plaintiff who has called this court session for a variety of reasons. Number one reason is that this person over here, attorney Marshal Willick, has attempted to freeze all of the business accounts that he is associated with, which is at best completely unethical and at worst unlawful. So you're saying that Marshal Willick did some unlawful things during the court process?
Correct. He attempted to freeze assets. He pretended like he had the court's authority to freeze bank accounts of a business that I own. So I'm a business owner. I have a business that has hundreds of employees. What happened in this case is Marshal Willick sent out notices to all bank accounts that he could get knowledge of that were associated with the business, and attempted to freeze all those accounts, so active bank accounts.
The person to the right of Toby Mathis is lawyer Joseph Scalia. We'll get to him in just a moment. The person to the right of Joseph Scalia is Larry Weinstein. He is the business lawyer for Toby Mathis, and he is here to argue that what Marshal Willick had done in trying to freeze Toby Mathis's business-related bank accounts was due cause for censure, fines, and even disbarment.
Good morning, Your Honor. Before we proceed to the merits, as a housekeeping matter, we should address the purported appearance of Mr. Weinstein for a purported intervener. We have not been served with even a motion for intervention of any kind, nevertheless an order granting any such intervention. We don't believe Mr. Weinstein's properly before the court in any capacity of any kind. We believe the motion filed is a fugitive document which should be sua sponte stricken, and Mr. Weinstein should be directed to observe if he wishes but not participate in these proceedings.
Thank you, Mr. Willick. That is actually first on my list to address this morning. Thank you.
Let me put this in perspective. Let's say that you were a shareholder in a company. Normally, you'd be looking at the value of the company. What Marshal Willick attempted to do was freeze those accounts so that he could probably use it to extort additional funds out of the, in this case, me. That certainly looked to be the case, is let's bring your company to its knees, let's stop you from being able to do payroll, let's stop you from being able to pay your bills.
And this has nothing to do with the family law. You're just going through a divorce and custody hearing.
We had just started the process. I had filed for divorce. So anything with an account number on it, he sent a freeze notice, which you cannot do unilaterally. Your court could order it, and before the court would order it, they would order a hearing so you could see whether it's even relevant or not. But what he did is he just went ahead and said, freeze this account, pretended like he had a court order, brought it up. The court actively protected him.
Your Honor, I can move this along here, if Your Honor allows me
Any
to.
stipulations? Let's start with that.
Well, I think I don't know if we have any formal stipulations, but the facts are the facts. Your Honor has seen the drug results of Brenda. All right, she could have been, in theory, arrested on her way to take the test. She's 5 to 8 times the legal limit for a DUI.
So what Joe's talking about there is that at the first hearing, they said that my wife was not doing drugs and I was a horrible person. They accused me of all sorts of things. We asked, I'll take any drug test you want. She takes any drug test. And the court said, that's a good idea. She took a drug test, and right after the hearing, she was 5 times the legal limit.
Wow.
So she was high there, and they were saying that she wasn't doing anything. She says that they knew that she was doing drugs, and they said not to say anything and to deceive the court, and they misled the court.
That being said, she at this point has hit bottom, and she's gone to the Meadows, and she's enrolled in the treatment program, which is in the benefit of all concerned. So we're all happy about that. So in the interim, I don't think there should be too much of a problem with granting Toby exclusive possession of the house.
Except that Toby didn't want that, and I was asked that
I'm gonna.
she's released.
So we can get into this. The reason we didn't want to do it last time was because we had this issue of of the children. Now that Mom came up extremely dirty from her recreational drug use, as the defendants have contended, we realize now it's beyond mere recreational.
Like recreational hard drug use
Doesn't
on its own is a play on words. I mean, that's a fraudulent representation because there is no such.
The reason we didn't seek exclusive possession last time because we did not have the proof of the myriad of allegations we've been making that her drug use was completely out of control. The defendant denied any drug use.
I know, I was here.
Right, so now that we have the drug results back, she is in Meadows in Arizona. I don't see any reason why Toby shouldn't be granted exclusive possession.
Where are Miss Bailey's children?
In the home with Toby.
Request for exclusive possession is denied.
Okay.
Oh my God! So they just I forgot all about this part too.
Mm-hmm.
They denied a request for exclusive possession of the home. She is in the Meadows. She's in a rehab, and I'm taking care of the kids, her children and my children, and they just denied my request.
The main issue here, of course, is the disgorging of the funds by counsel. $23,000 from someone who is a drug addict.
My attorney, if I remember right, was about $3,000 for that same period of time.
Mm-hmm.
So these guys took 10 times the fee from somebody who was obviously not completely lucid. So there's a question as to whether she had the capacity to enter into the contract.
In the decision behind Rafael Acosta versus Yoli DaCosta, the judge in the case recites how Mr. Marshal Willick was trying to get paid in excess of $200,000 for what amounted to 20 hours of work across a 2-year span. The judge stated that this was not a reasonable sum that could be enforced, calling it outrageous and unreasonable, and stating that the real amount should be only $9,209.
I'm not sure how a law firm can accept such a sum, or someone with a drug problem of that magnitude has the capacity to even form the intent to create a contract. Let's talk about their knowledge of the facts. According to their pleadings, they denied categorically, not only in this case, but the other case, that their client had a drug problem.
Well, you know what, Mrs. Scalia, not that I need to defend the Willick Law Group.
Judge Gail Nathan, as you heard, just said not to defend the Willick Law Group, and then she goes on to defend the Willick Law Group.
But the court recalls that there was a letter from a mental health professional and or a drug counselor saying that Miss Bailey just used drugs recreationally.
It's not marijuana.
It's not marijuana. No, she was in rehab for hard drugs.
Hardcore drugs in the cocaine, meth, heroin variety of drugs.
Hard drugs.
Hard drugs, wow. So the idea of recreational hard drugs is just ridiculous to begin with.
Correct.
Wow.
And so I think that any lawyer would have some reliance on a representation made by a mental health professional.
I would suggest, Your Honor, that the lawyer also has a duty of diligence in speaking with the client to ferret out the truth. I think certainly an experienced attorney like Mr. Willick would not put his client, who's really at this point a drug addict, through a custody battle. I think that part of our job as counselors and as attorneys, we would say to our client, you know what, that is not in your best interest right now.
We're just saying that you're misleading the court. You knew that you tried to underscore or understate or conceal issues. She was like, they completely lied to everybody. She said right out the gate, here's my issue. I'm suffering from this.
Suffering from drug addiction.
Yes. She said she made them aware of what was going on. And then after she went through rehab, she still tried to get the monies back.
All right, Mrs. Scalia, I understand your argument on fees. Anything else?
So we're getting back to the disgorgement of the fees, Your Honor. I think that, and I understand that it's like baseball. No one can bat 100 all the time. But I think the facts of this case and the law of this case is argued. I mean, I've seen better defenses raised by the Pro Bono Project, really, Your Honor. And for them to come in here and argue $23,000 in fees under these facts and under this law goes beyond the realm of ridiculous. Well into the world, of absurd. Those fees should be disgorged, or at the very least, charged back to the American Express account. They should be paid on a quantum merit basis. I'm not saying that they shouldn't earn something. They should earn something.
And I'm looking at it going, hey, wait a second. You lied to the court. There's no other way. You attempted to destroy somebody. Maybe that's the ordinary course of business and family law, but that didn't seem proper. I caught you.
They did all of these motions, seizing all these accounts, which I would call that rookie mistake 101. An over-aggressive attorney right out of law school would start seizing bank accounts which had nothing to do with the parties.
He turned up the heat on Willick, saying, this is definitely sanctionable activity. Any judge that I'd worked with would not have been happy, would not have been pleased, right? Would have definitely hit him, and more than likely he would have been censured or disbarred.
They made a big mess of this. I came in here personally to pick up the order to unfreeze the accounts. I had to do it on my day, and I called Mr. Willick, and I called the opposing counsel that day. Mr. Willick was in the meeting, never called me back, never did anything at the spot what I was doing, because had the banks had those accounts freezed, Anderson Law Group could possibly maintain an action against the Willick Law Group downtown. But I did it, even though I called them numerous occasions. Now, I didn't do it out of charity. I did it for the well-being of my client, obviously, but it's something that they made this mess, and now they wish to withdraw from this mess that they created. So I'm going to oppose their motion to withdraw.
They moved to withdraw. And we were blocking them, saying you should not only, you shouldn't be allowed to withdraw. You took a bunch of money and you made a mess. You shouldn't be able to walk away from it.
They wanted to walk away from their client?
Yep.
They want to walk away from their client while their client's in rehab.
Exactly. That's exactly.
And basically leave her completely on her own. She doesn't have an attorney now.
Correct. And they did.
Wow.
They absolutely did.
I think that has had a drug problem, and until we're completely sure that she's completely rehabilitated, she has to have counsel. And they've been paid. And I would prefer that she have counsel and go forward, so that way we don't have a problem later to say, oh, she wasn't represented. I oppose their motion to withdraw, and I think that some of the funds they've earned so far should be disgorged on the facts of this case as they are before your honor today. I think that's what has to happen.
Sure. Basically, as far as the fees go, there should be no disgorgement. We've worked, we've earned the money. She signed a contract, said that she would pay her bill of hours. That's what she's done. As far as what he's just said about the order, that went around our office. I was out of town. Mr. Willick was not available. Someone from his office contacted our secretary and said, the order's ready, we picked it up. We had no idea why. Your law clerk had not even contacted us yet. So whatever he's done on that side of it, there has been a breakdown in communication with our office and our client. We cannot at this time continue to represent her, and unfortunately I can't divulge to the court what has been said, what hasn't been said, whatever. As far as the issue with the bank accounts, based on, I don't know if you've had the opportunity to read what we got filed for you yesterday, but there's documentation in the letter that was attached as an exhibit. There's also the way that they have been throughout the marriage with the way he's handled the money and always taken it out of those accounts from the businesses. Mm-hmm. That did have something. And then when he totally cut off all her access to any kind of funds, there is an issue with it, and we had asked for that in our initial motion. Didn't get heard, it got continued. We had no choice after he cut her off is when we went and worked that way.
Carrie's trying to make an argument that I got paid out of business accounts, therefore you should be able to freeze said business accounts.
Mm-hmm.
So if you get a paycheck from a business, if you get dividends from a business, whatever, they should be able to freeze that business? Nonsensical.
It's nonsensical. There's no legal basis.
There's no legal basis, and they know it.
Mm-hmm.
I don't really have anything else to add. Mr. Willick is going to add something about the fees, I believe.
Very briefly, Your Honor, and I don't wish to make a long record of it. There is no difference to how we litigate our cases, whether we're representing a client pro bono or on retainer. The statement that there should be is loathsome. I have been insulted in this courtroom. I've been assaulted in this courtroom. I asked not to be interrupted. I bit my tongue.
Please advise Mr. Willick to address the court and not counsel. I'm not the judge here. You're the judge here. He should address you, not me.
I am doing so, but I asked Mr. Scalia to sit down and shut up.
Your Honor, really, Mr. Willick, this is really completely unprofessional. This is... Stop! He's having an outburst.
Please.
Mr. Willick.
Both of you.
I mean, is it even proper to say things like stupid and, you know, we heard him bang on the table there and
you would
addressing...
not get, the judges I worked with, you would never get away with that. Mm-hmm. You can't behave that way in a court.
Yeah.
So there was some familiarity there that allowed him to believe that he could do that.
That he could get away with that.
Yeah.
Okay.
I want 5 minutes of uninterrupted time, then I will shut up and go away. I am not in the mood today for histrionics. I am not in the mood for personal attacks. I am not in the mood to be insulted.
Mr. Willick states that he's not in the mood for histrionics when his behavior has been the only outlandish and contemptuous behavior in the court of law.
Your Honor, he should address you, not me.
But I asked Mr. Scalia to sit down and shut up.
Completely unprofessional. This is... Stop! He's having an outburst.
I asked not to be interrupted. I bit my tongue.
Please advise Mr. Willick to address the court and not counsel. I'm not the judge here. You're the judge here. He should address you.
Now he's mad because I'm watching a child. I'm watching somebody who makes it about them, a narcissistic jerk.
We seized nothing. A JPI was sent to bank accounts. It's all perfectly legitimate.
Actually, Mr. Willick is lying here. Trying to freeze bank accounts without a court order is not legitimate.
The attachment of a piece of one of my legal notes claiming that the court has the authority to enforce a JPI, which of course is true, is stupid and irrelevant to the issues currently before the court, as is the filing of a motion complaining about ATM withdrawals by a person on vacation and normally scheduled hair maintenance.
The drugs that she was getting, she was taking ATMs out of North Las Vegas, things like that, and then they tried to say it was for hairs.
We understand that's more of a concern for some people than others.
So like we were saying, look, she's hitting ATMs. We need to keep her from getting drugs. This is the only way I know how to do it. And they're just trying to cover it up by saying, oh no, it was for this, it was for that. No, she had credit cards for those other things. She was getting cash so that she could get drugs.
To the issues currently before the court, as is the filing of a motion complaining about ATM withdrawals by a person on vacation and normally scheduled hair maintenance. We understand that's more of a concern for some people than others, but it's a perfectly legitimate expense. There was no harm, no foul. This motion should have never been filed. It was taken care of at the last proceeding. It is a transparent effort to waste money, consume the funds currently sitting in our retainer account because the guy sitting at the other table has all the money. The only thing he's pissed off about is that she managed to get some of it before he managed to cut her off by using the credit cards. There has never been a motion, certainly not an order, certainly not an opinion, in the state of Nevada where the moneyed spouse asks for disgorgement or, God help us, sergeant equalization from the non-moneyed unemployed spouse. The whole premise of the motion is beyond stupid. It should have never been filed. The court could sua sponte issue sanctions for filing that pile of crap. In the meantime, because of our communication difficulty with our own client, and because we are forced, because of an internal matter relating to our office and our contract with our client, to withdraw, we ask the court to permit the withdrawal. If you want to space it out until after our client is released so that we can communicate with her and allow her time to get new counsel, that would be fine too. In the meantime, the funds sitting in our retainer account, and I don't have I don't have an accounting, but I will be putting...
All right, we're going to go off the record for a minute. Counsel, can I see you?
It gets to a point where Marshall clearly looks like he's having an emotional breakdown, is the way it read to me, right?
Yes.
But then the video cuts.
The judge stopped the video.
Why did the judge stop the video?
She's biased.
She's basically trying to cover up for Marshal Willick at this point?
That's what it appeared. She cut off the video because he was losing it.
He was losing it.
Yeah, he lost it. He started going crazy. Pointed his finger, slapped the table a bunch, started crying. I remember him losing his stuff, and I remember them going back in chambers. I remember him getting escorted out of the courtroom by the law enforcement and removing him, and then denying every one of my motions.
Gail Nathan, an alert came up saying that Gail Nathan was a possible relative or an associate of his.
Incidentally, the address of Gail Nathan today as a private family law attorney, as she was voted off the bench as a judge, appears to be the exact same address as the Willick law firm. These two, Marshal Willick attorney and Gail Nathan, former judge now attorney, literally reside their businesses under the same roof.
The judge ordered the return of all videos. I'm kind of shocked that you have one. If you have a copy of the recording, you have to return it to the court. I was shocked that after the hearing, I get a call from my lawyer saying, "You're not going to believe this, but the judge is ordering all copies of that video be destroyed. You're never going to see a copy of the hearing."
This act of the judge ordering all copies of this video destroyed of a court hearing, explain what that means.
It means that nobody will ever see a record of it. I mean, she's destroying that the hearing ever took place. These are public hearings, but it seems like it's covering something up because I think the public would want to know that this guy is unhinged when you're taking him on and is willing to do things that were unethical, if not illegal.
I will say that Marshal Willick is the best at what he does, which is to make a lot of money, influence politicians, judges, and do anything to drag out and win a case, no matter if he has to break the rules, and no matter how many lives are ruined in the process.
I had never seen the type of behavior from Marshal Willick in a courtroom, period. And not only did they not do anything to him, but Judge Nathan seemed to go out of her way to make sure that this video never saw the light of day. The hearing, in essence, is like it never happened.
You still lost. That part happened. I mean, I guess I'm trying to understand why that's not a gross violation of due process.
It would, as the party sitting there, I can tell you, it felt like a gross violation of due process. But
I mean, you're given the loss, but at the same time, you don't have the evidence to show why you should be able to be entitled to an appeal and why that decision was wrong.
The system appears to benefit those parties that are willing to bend the rules in their favor. And the only reason somebody could do that over a long period of time is if they weren't afraid of the rules and nobody was willing to enforce the rules against them. Would make sense. Like, why would you change if you're getting great results bending the rules?